Hello, this is Sandy again, back with Stephen Avery versus Wisconsin, versus the state of Wisconsin. We left off on page 32 with the court speaking, and that's where we will begin. I'm trying to give you a picture of this, or a shot of this as I read it, but it might be a little too shaky, but I will try my best for you to be able to see this. It's not very comfortable, but we will do it, and we will see how this works out. Ready? This is the court. Ready? Let's begin. Before you find the defendant guilty of this offense, the state must prove, by evidence which satisfies you, beyond a reasonable doubt, that the following 5 elements were present. 1. The defendant confined or restrained Teresa Halbach during her lifetime. 2. The defendant confined or restrained Teresa Halbach intentionally. This requires that the defendant have the mental purpose to confine or restrain Teresa Halbach. 3. Teresa Halbach was confined or restrained without her consent. 4. The defendant had no lawful authority to confine or restrain Teresa Halbach. 5. The defendant knew that Teresa Halbach did not consent and knew that he did not have lawful authority to confine or restrain Teresa Halbach. Although this requires genuine restraint or confinement, it does not require that it be in a jail or prison. If the defendant deprived Teresa Halbach of freedom of movement or compelled her to remain where she did not wish to remain, then Teresa Halbach was confined or restrained. The use of physical force is not required. One may be confined or restrained by acts or words or both. You cannot look into a person's mind to find out intent or knowledge. Intent and knowledge must be found, if at all, from the defendant's actions, words, and statements, if any, and from all the facts and circumstances in this case bearing upon intent and knowledge. If you are satisfied beyond a reasonable doubt at the conclusion of the trial that all 5 elements of this offense have been proved, you should find the defendant guilty. If you are not so satisfied, you must find the defendant not guilty. In reaching your verdict, examine the evidence with care and caution. Act with judgment, reason, and prudence. Defendants are not required to prove their innocence. The law presumes that every person charged with the commission of an offense is innocent. This presumption requires a finding of not guilty, unless in your deliberations you find it is overcome by evidence which satisfies you, beyond a reasonable doubt, that the defendant is guilty. The burden of establishing every fact necessary to constitute guilt is upon the state. Before you can return a verdict of guilty, the evidence must satisfy you, beyond a reasonable doubt, that the defendant is guilty. If you can reconcile the evidence upon any reasonable hypothesis consist with the defendant's innocence, you should do so and return a verdict of not guilty. The term reasonable doubt means a doubt based upon reason and common sense. It is a doubt for which a reason can be given, arising from a fair and rational consideration of the evidence or lack of evidence. It means such a doubt as would cause a person of ordinary prudence to pause or hesitate when called upon to act in the most important affairs of life. A reasonable doubt is not a doubt which is based on mere guesswork or speculation. A doubt which arises merely from sympathy or from fear to return a verdict of guilt is not a reasonable doubt. A reasonable doubt is not a doubt which doubts such. A reasonable doubt is not a doubt such as may be used to escape the responsibility of a decision. While it is your duty to give the defendant the benefit of every reasonable doubt, you are not to search for doubt. You are not to search for the truth. As you know, although this is a Manitowoc County case with a Manitowoc County jury, the case is being tried at the Calumet County Courthouse. You will learn that when Stephen Avery became a suspect in this case, the Manitowoc County District Attorney turned control of the case over to the Calumet County District Attorney because Mr. Avery had a lawsuit pending against Manitowoc County at the time. For logistical reasons, the parties jointly requested that the trial be held in Calumet County, and the court granted that request. You should draw no inference for or against either party to this case because of the location of the trial, or the fact that it is not being prosecuted by the Manitowoc County District Attorney. In a few minutes, the lawyers will make opening statements. The purpose of an opening statement is to give the lawyers an opportunity to tell you what they expect the evidence will show, so that you will better understand the evidence as it is introduced during the trial. I must caution you, however, that the opening statements are not evidence. At this time, we're going to take a very short break so that the state may get its equipment ready to present the opening statement. We'll be back in a few minutes. Jury not present. The court. 5 minutes, counsel. Attorney Kratz. That's fine. Recess taken.